Aloha mai kako. I'm Lila Mower, president of Kokua Council, one of Hawaii's oldest advocacy organizations, representing and advocating for the most vulnerable among us. Before I begin our general meeting, I'd like to announce that we've located a venue where we may once again meet in person and via Zoom. The Hompa Honganji Hawaii Betuing, more commonly known as the Pali Honganji. Details will follow next month. Today, Kokua Council has the privilege of meeting with now retired, award-winning federal defender Alexander Silvert, who wrote the Mailbox Conspiracy based on his involvement in the Louis and Katherine Kealoha case, a case which exposed corruption and deceitful collusion in the upper echelons of Hawaii's law enforcement. The case disrupted our everyday ordinary lives because the crime felt shockingly closer to home. These events did not occur in the Capitol building or in City Hall or in other government offices, aloof and distant from us. The crime involved the police, whose daily protection and care we depend upon, and it occurred in the prosecutor's office, where crime and criminals should be checked and impeded. I wonder, will Mr. Silver touch upon the federal investigations related to this case that are still ongoing? Will he share his concerns about Voldemort, he who must not be named, who's alluded to in this book? If what I say sounds cryptic, I encourage you to read Mr. Silvert's excellent book, The Mailbox Conspiracy. Mr. Silvert, please share your experiences with us, and then during the last half an hour of today's meeting, allow us to ask questions. The floor is yours.
Well, thank you, Lila, and thanks for inviting me, everyone, to speak to you. I really appreciate the opportunity. And I love speaking to groups like this because I know you're interested. I know you're going to ask great questions. I know you were following the Kealoha case in the news as it was happening. So it's great to speak to people like you who have some familiarity with the topic. And so I'm really looking forward to the questions. Let me tell you a little bit about myself first. You can tell by my accent, I'm not from Hawaii. I'm originally from the East Coast. My parents were both professors. My mother, very liberal, would take me to demonstrations when I was young in the 60s and 70s. And that's how I grew up, in a kind of a professorial household. But I grew up on the East Coast in Vermont and New York City, ended up going to school at UCLA and graduating from there. Then I went back to the East Coast, started to get a PhD, and then moved over to law. And I went to Boston College Law School. And during that time, I was driving a cab in New York. So I'm still I feel like a New York City cab driver as I drive around. And ended up meeting my wife in law school, and she was from here. And we lived in Philadelphia for 5 years, had our first son. And when my first son was 3 weeks old, we decided we were going to live in Hawaii with her parents. And we moved here in 1989. I was a state and federal public defender in Philadelphia. And when I moved to Hawaii, I moved into the federal public defender's office here. In 1992, just a couple of years after I got here, I was named the first assistant federal public defender, which means I kind of ran the day-to-day operations of the lawyers and the staff in the office. I assigned cases and had a huge caseload of my own. And I was in that position all the way till 2020 when I finally retired. The book I've written, and the subject of today's talk, is called The Mailbox Conspiracy. And I wrote the book for two reasons. One, a lot of people really don't understand what happened to Gerard Puana. Everybody kind of knows a little bit about the Kealohas and their trial, but the Puana case was what set that off. It was the trial that a lot of people didn't hear about, where Mr. Puana was actually innocent, which is rare when you're a federal public defender. I can count on one hand how many people I represented who are innocent. So I wrote the book because I really wanted to exonerate Gerard and Florence Gerard and their family, because a lot of people think, well, maybe they got off on a technicality, those kind of things happen. But I wanted to really clear their names, because Gerard was framed, and Florence, who lost hundreds of thousands of dollars, lost her home. So I wanted people to understand what really happened. But the second reason I wrote the book is because it really is a blueprint, step by step, of public corruption. By reading the book, you can actually see how it works, how other people look away when they shouldn't be, and how our oversight committees, like the Police Commission or the City and County Ethics Commission, even the Office of Disciplinary Counsel, which is the office that oversees all the lawyers in Hawaii, really fail in their responsibilities. So part of the book is kind of a blueprint of how corruption works, and a cry at the end for us to do something about it. Because unfortunately, many of these very same institutions that failed to do anything about it have absolutely refused to look back and figure out why they didn't act and what they need to change in their procedures so it doesn't happen again. And I wanted to educate people about that, because the only way we, the public, are going to change anything is if we're aware of what happened. And if politicians and commissions aren't willing to change, then we, the public, have to do something. We have to lobby, we have to vote, we have to change the way things work. So the other thing I wanted to say about the book before I talk about it a little bit is this is not a law book. So for those of you who are afraid to read this because you think this is some kind of trial book or law book that's going to get you in the weeds, it's not. I do talk about the law in it, but it's more written like a murder mystery. And even though we know what happened, you will walk with me step by step as I expose and find out what really happened. And so the book takes you through the investigation and my representation of Gerard Puana and the Puana trial. And I'm going to show you today some of those documents and talk about some of the evidence we uncovered. Then the book takes you through how we got the FBI and the U.S. Attorney's Office interested and willing to investigate this case. Because remember, we were asking them to investigate their own, and it's not easily done. And to their credit, after I was able to present the evidence to them, they were able to see and understand what was happening, and they were willing, because there's a political cost sometimes to U.S. attorneys who want to investigate their own, or the head of HPD. There can be a political cost to pay, and they took that step. They were willing to do it, so they deserve a lot of credit for that. And so I walk you through that process, and then we go all the way through, of course, the Kealoha trial, where I was a witness for more than 5 hours. And I walk you through that process and everything that happened up until everybody was sentenced. So you get the whole picture over 7 years, because this case actually began in June of 2013, and the Kealohas were finally sentenced in November of 2020. And as some of you may have known from the news, some of them are already getting out of prison. So it's really been a long process. And there have been other cases that have resulted from the fallout from this case, and I will try to get to those a little bit towards the end. If you're interested in getting the book, it's at Barnes & Noble's, it's on Amazon, it's at Bookends. So it is available, readily available to you. If you order right from Watermark, which is a local publishing company, they will send you the book at no cost. So you can support local business by doing that as well. So the first thing I want to, I don't know why this is, hold on. First thing I want to talk about is, I'm a public defender. I represent criminals in federal court. I don't represent really good people. That's my job. When a person can't afford an attorney, they get the federal public defender's office. And actually, we're considered the best law firm no one can hire, because all we do is represent people in federal court on criminal charges. We have no other responsibilities. So we are very focused. We really do know the law. There are a lot of private lawyers who'd like to work for us, but we only have 7 attorneys in the office who do all the cases. And every year, our office, while I was there, would represent anywhere between 60 to 85% of all people charged in federal court. That's a lot of people. But very few of those people ever go to trial. Most of my job and most of the job of a defense attorney is to mitigate for either working out a guilty plea to better charges, less reduced charges, or going to sentencing and trying to get the best sentence we can. Very, very few people actually go to trial. So all those TV shows you see where everybody's in trial and they give these long speeches, that's actually a rarity in federal court. And to illustrate this, I wanted to show you this chart. So on the left side, we have the nationwide average of people who plead guilty in federal court, and that's 96.9%. This was from 2008 to 2009. Those numbers really haven't changed. In Hawaii, the average was 96.4%. So out of 100 people who I would represent, 96 or more would plead guilty. Very few people go to trial. So in this case, it was a rarity when a client comes in. A lot of clients tell me, they're innocent or they didn't do it. And then, of course, it doesn't take long to figure out that they really did. And a lot of clients make you do the work to, that you have to go through to kind of show them they don't have a chance. But this was a case where when we got the case in the office, I took the case myself because having already been working for 26 years in the office, I'm looking for any kind of case that's different. We always have drug cases and bank robberies and Ponzi schemes and fraud. I was looking for something that was a little different. And a case like this, the charge of theft of a mailbox, I had actually never seen in my entire life as a federal public defender in federal court. It's not the type of case brought in federal court. So it was unique. I didn't even know anything about it at first. So I decided to handle it myself. But quickly, I learned that my client, Gerard Puana, was charged with stealing the mailbox of the chief of police, Louis Kealoha, and his wife, Katherine Kealoha, who at the time was the third highest ranking city and county prosecutor in Honolulu. And that alone made it extremely interesting. But I was also told that there was a video and that they'd captured the crime on the video, and that both the chief and his wife and another police officer who had seen the video, were all going to say that was Gerard in the video. So when you have a case that starts off with the video of a crime, which is very rare, and three very distinguished and very credible people who are going to say that person in that video is Gerard Puana, it looks like a pretty open and shut case. And we all know that witness identification is the worst form of evidence. It is highly suspect and usually wrong, but not when the people who are identifying the person in the video or the photograph know the person. So when that happens, the identification becomes very powerful. So when Mr. Puana came into my office and said, "I'm innocent, I didn't do it," it was one of those things where it was very hard to believe. The first thing that we noticed when we got the police reports is that the officers assigned to investigate the case were homicide detectives. And as one newspaper reporter wrote, he didn't know that any mailbox had been killed in the commission of the crime. And so it's very unusual right off the bat to have homicide detectives assigned to the case. And then we got the video. So the crime occurs around 11:28, 11:30 at night on June 20th of 2013. We were given 1 hour of videotape that contained a half hour before the crime, a half hour after the crime, and literally what you're going to see now of the crime itself. This is the video that was captured on the cameras that were at Louis Kealoha's house, and this was introduced into evidence at Puana's trial. But I wanted to show you a still photograph, which was also introduced. This is the vehicle that drove up. I want you to notice, and you can, when you watch the videotape, that you can't see the make and model of the car. You can't see the license plate. You can't see into the car. That was all later we learned staged so that you couldn't see it. And then to the left on this picture, you see the mailbox. Now we're going to take a very close examination of this mailbox as I present you some photographs. But during the video, I want you to look at the mailbox and how it comes off, and particularly the pedestal that it's mounted on. Because this is an expensive mailbox. This isn't the type you buy at True Value hardware store and you nail on a post. This is a aluminum metal mailbox. It weighs a lot. It comes with a pedestal, and it's unique to the mailbox. The mailbox and the pedestal are a system. You purchase them together. You cannot put a different mailbox on that pedestal because it's only built for that. And these things are sturdy like a rock because that's how they're built. So I want you to, when I play the videotape, to watch it. Now, there are two cameras that caught this. I'm going to try to play you the second one because the second one's much better. You can see it's kind of hazy right now, but the mailbox on the left, there's the car driving up. Now, the person who gets out of the car is identified as Gerard Puana, and he's actually wearing clothes that Gerard Puana would be most likely to wear. Now watch as he pushes it. You saw how that pedestal bent and how he just lifted it off? Right now, I'm going to try to get out of here. This is where things mess up on this thing. Okay. So this theft occurred allegedly at 11:28 p.m. in Kealoha on June 20th. On June 21st, the next day, and these are important things I'm going to tell you, at 1:28 or 1:30 in the afternoon, Katherine Kealoha calls 911. Just like you and I would, as an ordinary citizen, she calls 911 and reports the theft of her mailbox. Two beat cops show up and they process the crime scene. And one of the things they do is they take photographs. This is actually a photograph taken by the police officer who came at 1:30 in the afternoon. This is the pedestal that was left after the mailbox was stolen. He also takes a report and a statement under oath from Katherine Kealoha. And she tells the officer what kind of mailbox was in front of her house. And she gives a description. They write it down. The homicide detective that you saw, who was assigned a couple days later, writes a report. He puts this description of the mailbox and the pedestal into his report. And whenever there's a theft, HPD actually has a detective who's trained as an appraiser, just like someone inspecting your home to appraise your property. They're trained as an appraiser to independently verify the item that was stolen and the value of it. And the reason that's done is because under Hawaii state law, the type of charge that you will face under the theft statute depends on the value of the property. Obviously, the lower the value, the less serious the charge. The higher the value, the more serious the charge. Under Hawaii law at the time, anything that was valued over $300 is considered a felony. And a felony is a more serious charge than a misdemeanor. It carries certain penalties. It also carries very, very severe penalties for you can't ever vote. You can't vote while you're in prison. You can't own a weapon, you can't own ammunition. It prohibits you from getting certain funding, like going to college. So a felony is very different than a misdemeanor. But in the law, a felony is also something, a felony theft is something that I, as a lawyer, if a witness has a felony theft conviction, I can use that conviction against them at a jury trial to tell the jury, you shouldn't believe this witness because he's a thief and he's been caught and convicted of a felony, and therefore his credibility is at issue. So the difference between a felony and a misdemeanor is that with a misdemeanor, you can't do that, but with a felony, you can. So Katherine Kealoha, you'll see in a moment, values this mailbox at $375. The HPD independent expert values this mailbox at $375. So it's a felony crime. And in fact, when Gerard was arrested initially by HPD, he was charged with felony theft. So this is the Gaines mailbox that they claimed, according to that description, was on top of that pedestal. So the first thing we did in investigating the case was we took a photograph of the pedestal that you saw, and we sent it to the Gaines Manufacturing Company. And we said, can you verify that this is your pedestal and that this is your mailbox? And to our shock and amazement, because this was one of the first things we did, they came back and said, no, that's not the pedestal that belongs to us. We don't make that pedestal. But better yet, they said, we know the company that does make that pedestal. So we took the pedestal photograph and we sent it to them. And they came back and said, yes, that's our pedestal. And this is the mailbox that actually belongs on top of that mailbox. Now, remember what I said earlier, the pedestals and the mailbox are unique. These are systems made for one another. You can't put other ones on them. So we knew almost immediately that they weren't telling the truth about the make and model of the mailbox, but we wanted to be sure. So we went and purchased it. You can see what it looks like. It's different pieces, but you can see the difference between the two. But the most important, so you can see they don't look anything alike. But most importantly, the thing that we found was that the mailbox on the left, which is the one we believed was actually in front of the Kealoha residence, is valued at $170. That's a misdemeanor. That's not a felony. So we realized they were lying. I mean, it's bad enough you're lying about the make and, of the item that was stolen. But now we realized they were lying about it because they needed it to be a felony and not a misdemeanor. And if they told the truth, it was a misdemeanor. And then if you look at the photograph that this is taken from the still photograph, you can see it's clearly not the mailbox on the right, it's the mailbox on the left. But we wanted to be sure because we had to prove this to a jury. So we went and got other photographs from the family. We went to Google Maps and got photographs, and you'll see that in a minute. And we could, so that we could prove that that was in fact the mailbox in front. We had all these pictures taken, from family members, and it proved without any doubt that it was the cheaper mailbox in front of the house, not the more expensive. But we went back, and right before trial, we actually subpoenaed the person who built and manufactured that mailbox. So we had a witness from the Gaines Mailbox Company who was going to say, that's not our pedestal, that's not our mailbox. And we had a witness from the Solar Group mailbox who was going to say, yeah, that's our pedestal and this is our mailbox. But when he took a look at the video and he took a look at this picture, he told us that if you look at that little orange nut that appears to be at the top of the bolt where it's circled, that's not supposed to be there. When you build this properly, that nut is not there. Because the way this works is running up the middle of this pedestal, and you can see it is the bolt. It's a 3/4 inch bolt. It runs all the way up. You sit the mailbox on top of it with the base, and from inside the mailbox, you screw in the bolts that tighten the mailbox onto the base. So you cannot unless you have access to inside the mailbox. You cannot unscrew it. You tighten it by revolving it, and the whole thing solidifies into one solid uniform base and mailbox that cannot move because it's also cemented into the ground. So according to the manufacturer, this couldn't move like you saw in the videotape, except we deconstructed the mailbox that we bought. We put the nut on top. We placed the mailbox on it. And what happens is, because the bolt has a few threads, you can't lift the mailbox off directly, but you can lift it off to the side, just like you saw in the videotape. So he said, if you lift it off the mailbox like that, either the entire bolt has to come with the mailbox because it's attached, or it has to snap, and it can only snap at the base. The bolt's not snapped in any location. So his conclusion, and he was ready to testify, was that this was rigged. Now, this is a copy of Katherine Kealoha's statement under oath to the police officer on June 21st. And you can see that she says the value is $380. And she signs this under oath. But what I want you to look at is, try to look at that 8 in the 380. Compare it to the 8 in the line above, the 18 inches and 18 inches. Not the same, right? It looks like the 8 on the 380 is actually a snowman, right? It looks like she may have written 300, and then someone, or her, we don't know, made it 380. Why? Over $300 is a felony, not 300, over 300. So this document was altered, either by Katherine or by someone else. When you're a defense lawyer, you're always looking at police reports, not only for what they say, but for things like this, mistakes, things that look like a document was fudged or redone. Mistakes are common in documents. People make typos, those things are common. You're looking for something really telling. And something like this 8 is very telling. The other thing that happened was, I am a federal public defender. I'm familiar with federal law. I'm not familiar with state law. Katherine is a state prosecutor. She's familiar with state law, but she's not familiar with federal law. Katherine mistakenly believed that in order for this to be a federal crime, because after he was arrested 2 days later, it came over to federal court. So Katherine mistakenly believed, we believe, that you actually had to have mail in the mailbox to make it a federal crime, that stealing the mailbox itself was just a property crime, but stealing mail is the federal crime. So you can see on the left is her first statement she gave on June 21st. And it says that it doesn't say anything about there being mail in the mailbox. It says that she thinks that one of her family members has the video and they'll get a copy of it for HPD. But on the right, by June 29th, when the case has gone federal, she claims she went out to the mailbox at night, looked through the mail, took a few pieces, left a few pieces, and went back home. Now, first of all, how many of you are going to go out at 11 o'clock at night and look through your mail and leave some in the mailbox? You only say that if you think you have to have mail in the mailbox to make it a federal crime. So these are the kind of things, differences in statements and why there are differences in statements at different times that we as defense attorneys are looking at, and later as prosecutors to say, wait a second, this person is making this stuff up. Now, one of the things that happens in every case is when evidence is seized by the police, they have to record it, log it, and they make what's called a chain of custody report for every piece of evidence that's seized. A chain of custody report, I like to say, is like an inventory on steroids, because it's critical for the police to log everything that happens with that piece of evidence, so somebody like me can't at trial claim it was fudged, it was contaminated, it was altered in any way. And you do that by having an officer assigned who's a custodian of record, who logs every piece of evidence, puts it in a safe, and then has a log of everyone who touches it and everyone who had access to it. So in this case, Officer Silvert of the CIU, Central Criminal Intelligence Unit, which is a very specialized unit within HPD, it claimed that he went to the house the next day and recovered the hard drive, recovered the video you just saw. And he wrote a report. So the report on the right, you can see, is dated June 22nd, 1330 as the date and time of the report, of the reported incident when she called. But look on the left. He says he recovered that hard drive at 8:59 that morning. What time did Katherine Kealoha call 911? 1:28 in the afternoon. But Silva recovers the evidence 4.5 hours before Katherine Kealoha called 911. How's that possible? Now, I know there's great police work going on somewhere, but this isn't possible. So we knew right there, we had another piece of evidence. Something isn't right. And if Officer Silver is correct, and he recovered the hard drive at 8:59 in the morning, why did Katherine under oath in that statement I showed you just a moment ago say that the video was with a family member and she would turn it over to HPD when she got it back, if HPD already had it in their possession 4.5 hours earlier? Contradictions all over the place. I have to say, we were given a number of police reports in this case, and I've never had this happen before. Every single one either was false or contained omissions of fact that were critical or were altered. Every one. Not just one, which is sometimes even hard to find. Every single one. And this is why I'm showing you these documents, to kind of show you how this work played out. This is a document that played out in our trial. So on the right, this is, again, Officer Silver writing a report saying that he recovered the evidence. He made one copy, he released one copy. This is the document on the right that HPD presented as the official document, that they gave to the United States Attorney's Office as the official document, and was introduced at trial at the Puana case as the official document. We had, from the beginning of the case, decided that HPD was not telling the truth about this case and may have been hiding evidence, may have been altering evidence, and certainly may not have been even telling the U.S. Attorney's Office the truth. So I had independently, apart from the documents that the government gave me as the official documents, I subpoenaed HPD independently and got their documents from them, because I just wanted to see if there were other documents or anything else that I wasn't being given by the government. The document on the left is one of the documents that we were given by HPD in response to our subpoena. And you can see the difference. All of a sudden, the number 4 appears. Now, you can't see it from what I'm showing you, but on the bottom, Officer Silva signs it, dates it, stamps it. His supervisor dates it and signs it. And if you want to amend a report, which happens all the time, you have to file a separate report called an amended report. It's got a different date and time because it's been changed. You can't go back to the original report that's been authorized by your supervisor and just change it. And that's what happened to this document. Now, does it mean in reality that something happened to the piece of evidence that altered it and fudged it? Probably not, but you don't do this. This is just not proper police work. And when Officer Silva took the stand in the trial, the government introduced the document to the right as the official document. They didn't even know I had the document to the left. And I was able to present this to Officer Silva when he testified. And I'm going to show you later what he said, because it was not a very good answer. You know, people don't, when they're charged with a crime, there are elements of the offense. You know, if you rob a bank, you have to take something that doesn't belong to you without the bank's permission. And the bank has to be federally insured in order to make it a federal crime. So every crime has elements of the offense. In this case, motive, you know, why someone did something, why Gerard would have stolen the mailbox, for example, is not an element of the offense. If you watch television, they always talk about, you know, why someone committed the crime or why they would commit this murder. That's actually not something the prosecution has to prove. But, you know, you don't have to prove why the guy robbed the bank. You just have to prove he robbed the bank. But in this case, because we were putting HPD and the Kealohas on trial, we knew we had to convince the jury there was a reason they would do this, because otherwise no one's going to believe us. So we were looking for that reason. Well, in 2009, Florence Puana, who is Gerard's mother and who is Katherine Kealoha's grandmother, when she was in her 90s, wanted to buy a condo for Gerard. But like most of us who live in Hawaii, Florence was house rich, but cash poor, because she built her home with her husband right before Pearl Harbor. They owned that house free and clear, but she was living on Social Security. She had no credit. Gerard was disabled and living on disability. He had no credit. No one could get money and get a loan, but they had this house that had a lot of value. So they went and turned to Katherine Kealoha. You know, the Puana family is a big, big family. It's one of those huge Ohana families in Hawaii. But Katherine is the only one in the entire family who went to college and went to postgraduate school and became a lawyer. Everybody loved Katherine. Everybody respected her. Florence loved her. Puana she would call him Uncle Keister. You know, they all got along. So they turned to Katherine in 2009 and said, how do we do this? And Katherine said, you get a reverse mortgage. And the deal that they worked out, and none of this is in writing, but the deal that they worked out was Katherine would do all the paperwork. She'd get power of attorney, set up a mailbox. They would get a reverse mortgage for about $550,000 or $600,000. They would buy Gerard the condo, which was about $390,000. Then Katherine could take a little bit of the money and pay off some of her debt. And once her debt was paid off, she would have good credit again. And Katherine would get a loan, her own loan, pay off the reverse mortgage in its entirety. Gerard would then pay Katherine the amount of the personal loan that had to be paid back per month. So it seemed like a win-win deal. They would get the mortgage, they would buy the condo, Katherine would pay off the mortgage, and then Gerard would pay every month Katherine back for her loan. And that's what happened in 2009. They got the loan, they put the money in the bank, they bought the condo, and Gerard, for 3 years, paid Katherine what was supposed to be the money due for her loan. Well, what happens after 3 years? Banks sell your mortgage. It happens routinely. All of the documentation up until then had been going to the P.O. box that only Katherine controlled. But after 3 years, the new bank issued its letter saying, we're now your new bank. Here's the status of your loan. And they sent it to the house. They didn't send it to the P.O. box. Florence opens it up, and now she owes over $616,000 because not one penny of that reverse mortgage has been paid off. In 2012, she writes a letter to Katherine and says, what's going on? I've been trying to reach you. You don't answer your phone. The entire Puana family was trying to call Katherine. She would not answer or respond. So Florence writes a one-page letter. It's very nice. And it says, look, I don't understand what's going on. Please contact me. I'm revoking the power of attorney. And if you don't respond, I'm going to have no choice but to hire a lawyer. Well, a few days later, in response to that, Katherine writes 2 7-page letters. This is one page of one of them. The letters are addressed to Gerard and to Florence, one of them. The other is the entire Puana family. Some of the letters are capitalized, underlined, bolded, and they're just screaming. They are just outraged that she would be accused of having done anything wrong. I'm showing you the one letter because I wanted you to see what just one page looks like of 7. Now remember, Katherine is a very high, powerful lawyer. She's served in the legal administration as an administrative head of an office. She's been a clerk for judges. She's been in the prosecutor's office for years. Lawyers don't write letters like this. I've never seen a letter like this. And we had 14 pages of this. And it became the reason, the motive why she would lie. And in one of these letters, there's so many parts of it that are outrageous. In one of she's letters, she says, I will seek the highest form of legal retribution against anyone and everyone who has written or verbally uttered these lies about me. They will rue the day they decided to state these twisted lies. And rue the day became our mantra. It became the theme of our case in front of the jury, because this was the motive. This is her own words as to why she would do this. Now, in March of 2014, so remember 2013, 2012, they write the letter. 2013, March, the Puanas file a civil lawsuit against Katherine, claiming she stole all this money. If the Puanas prevailed in state court on that civil lawsuit, which is just about money, Katherine, as a lawyer, would probably lose her job and certainly would most likely lose her law license. So that civil lawsuit was a threat to Katherine. And we know it was a threat because of the letters she wrote. Well, it was June, only 3 months later, that Katherine claims he steals the mailbox. That puts the civil case on hold while the criminal case goes forward. And if he's convicted, when he takes to stand in the civil case to say this is what happened, he's going to be cross-examined by a lawyer who's going to say to the jury, don't believe Gerard Puana. He's a thief. He's a felon. He's a liar. Florence is easier for them to discredit because she's much older, doesn't have a great memory. But Gerard, much younger, has records, is a threat. And that was our theory of why this all happened. One of the things that happened here was you saw that car that you really couldn't make out. Well, in the police report, Detective Akagi, who is for the homicide detective, claims that he found the car. Now, Gerard doesn't own a car like this, but they actually thought he did. But he didn't. So now they had to find a car. They were desperate to find a car that he could have access to that drove up, because they thought he drove up with a white car because Florence had accidentally told one of them that he drove a white car when he didn't. So a white car is seen driving up. Now they have to find a white car. So a couple houses down from where he lives, they find a white car that seems to look like the car in the photograph. And it belonged to a woman named Carrie Arakaki. They interviewed her, and she said, I don't know, Gerard. My car is very unique. I'm a very small person. I push the seat way up. I have a rack of magazines behind the seat. and my car wasn't stolen. I didn't lend it to anybody. I didn't do anything like that. They made her take a polygraph test, which is very unusual. She passed the polygraph. But even though she passed the polygraph and said, I didn't lend the car, I didn't give it to Puana, they still wrote a report saying the car was stolen. When we showed the report in the video to her, because she was going to be one of our witnesses, she said, well, that's not true. She was very upset because she was a good citizen. She thought she was doing a good, what she needed to do. But the reason she said that it wasn't my car is because if you look on the left, her car has this windbreaker on the back. It has other distinguishing features too, but that's the most noticeable. And you can see there is no windbreaker on the back of that car. And that's pretty obvious. How could homicide detectives make this mistake? The other thing that we found was Gerard claimed that during the days leading up to his arrest, which was on the 29th at 5 o'clock on a Friday, that he was being followed. Now, according to Detective Akagi's police report, no one had named and identified Gerard even as a suspect until 5 p.m. on the 29th of June, when Katherine is brought to the station, views the videotape and says, oh, that's Gerard. That is the first time, according to Detective Akagi, that anyone identifies Gerard even as a suspect. His name is never mentioned up until this point. But Gerard had all along said to me, I'm being followed. I felt I was being followed. Gerard used to have a job as private security. So he actually was one of my greatest clients because as a former private security guard, he actually took photographs and he kept notes of the cars he believed were following him. As a client, this is like a gift from Mana. So, either he's telling me the truth or he's crazy and these are just paranoid numbers and cars that he took down. So he not only did he have that report, he had this, took these photographs from his car, from the rearview mirror or the side mirror. Well, because he took these photographs and we could look at the license plates, we issued a lot of subpoenas to find out who owned those license plates and who owned the cars. And what we found out, and this is is that these cars, and every car that we found, belonged to HPD, CIU, and Detective Akagi. But most importantly, because when you take a photograph, there's metadata that you can get off the photograph that tells you the exact time and date that photograph was actually taken. We could prove that he took those photographs on the 27th and 28th of June, 2 days before the 29th, when he is named a suspect. How and why can police cars be following him if he's not even named as a suspect yet? We also found out that Detective Akagi had gone to Kerry Arakaki's house and questioned her the night before Puana was identified. So all of this is happening before he's identified as a suspect. And we could prove it all. I'm going to pass this press for a little bit because so one of the things that was bothering us is, we had a lot on Katherine because she had written statements under oath. As I've already shown you, we had a lot to cross-examine her about with her letters and her statements, but we had nothing on Louis. Louis a very credible figure, and we have nothing on him. And so I went to the press because Louis not going to talk to us. Nobody has to talk to the defense attorney. So I went to the press and asked, kind of got them interested in the case, told them what the problems were. This is all before the trial, and said, got them to go and ask Louis questions for us. And Louis said that he actually said there had been prior problems at the house, that he had reported that, including a shooting with a BB gun that broke out the window of his front door and he claimed could have hurt his daughter. And he claimed that's why they put cameras in front of his house, because these are city and county cameras that aren't supposed to be used for private purposes. But he claimed that that's why that happened. Now, we subpoenaed HPD for any and all reports of incidences at Louis' house, and there were none, even though he made the statement to the press, including claiming they shot out the front of his door. You would think the head of HPD living in Kealoha would report that, because his neighbors might be, that might cause a problem. But he also said that he gave the report to his deputy chief McCulley, that on the night of June 20th, he noticed the mailbox missing. He noticed it in the morning, but that night he called Deputy Chief McCulley, reported it to her. She took over the investigation. She called CIU, and that's how it happened. He had nothing to do with it. Hands off. It was all Chief McCulley and CIU. That's the night of June 20th. Well, if that's true, why is Katherine calling 911 the next day at all if CIU is already involved? But more importantly, we were later able to determine that Deputy Chief McCulley, under oath in a deposition to the Ethics Commission on a separate matter, was asked, did you do this? Did he call you? Did you take over the investigation? And she said, no, that didn't happen. Why? She was in France on vacation and didn't know about the theft for 2 weeks until she came back. So now his statement to the press was false. But better yet, at trial, he changes his statement. He says, I went out in the morning to go surfing at 6 o'clock. I see the mailbox missing. I come back at around 8 or 9. I tell my wife, and we decide she's going to call 911. That's now his story. But that's not what he told to the press. The first day, I lay this out in trial. I know I'm running out of time, so I'm going to just do this very quickly. We had jury selection. This is all laid out in the book. I think even though this has to do with a trial, you're going to find it very amusing, because it was amusing kind of things that happened. The trial was over by the second witness on the first day of trial, because Louis Kealoha, in my mind, in my opinion, committed an intentional mistrial by stating that when he was asked to identify and describe what Gerard Puana looked like back in 2013, not in 2014 when the trial occurred, because they wanted to say he gained weight. So they wanted to tell the jury, the person in the video who was obviously thinner, that Gerard had gained weight since then. So they asked Louis to describe what he looked like back in 2013. Instead of describing what he looked like, he said, oh, he looked just like, and he paused and said he looks like just like he looked like in his arrest photo when he was arrested for burglary of his neighbor's house. Now, in a criminal trial, you can't say that. That's totally improper to bring up that charge. And it wasn't really the answer to the question. And Louis, I immediately stood up and asked for a mistrial. Louis, without any prompting, immediately apologized to the court. So he obviously knew what he said was wrong. And that's what caused the mistrial. And that's what set everything in motion of my going to the prosecutor afterwards, showing them the evidence I just showed you, and there's a lot more, and getting them interested in explaining to them that they had been hoodwinked and they had been lied to, and that this was a miscarriage of justice and they needed to investigate. There's a lot more I could talk about, but I want to give you time for questions.
All right, I'd like to open the floor to questions. Thank you very much, Mr. Silvert. Does anyone have any questions? You can use your raised hand icon or put something in the chat box. Okay, Doug, go ahead first, please.
Yeah, I just a brief question and kind of an obvious one. I mean, they were caught because of a number of errors they made and because of the position they held. And this requires a certain amount of speculation from you. How how common can this be? I mean, are people being set up rather than given fair shakes, or what do you think? I mean, this is
look, personally, I mean, look, most of HPD is very law-abiding, good police officers. I am not suggesting in any way or form they're not. And I'm not suggesting that this is widespread in the sense that most prosecutions and most police officers are honest. However, you know, I've been doing this for 36 years. What I would call is this. There are obvious occasions where they do either outright plant evidence, we've seen that, or falsify evidence, but that's a rarity. What police officers more commonly do is what I call gild the lily, is they put things in the report or they testify to things that they kind of exaggerate to make it look worse for a defendant. Not necessarily make, you know, evidence up or arrest somebody just on a lark, but they say things that, you know, they found something in plain view when it really wasn't in plain view. I mean, they did find the shotgun, but maybe the butt really wasn't sticking out that gave them the right to search the car. Or they say the defendant said something which they never said, which isn't in a police report. And that's very common. It's one of the things I feast on, is when a police officer gets on the stand and says, oh, you know, he said, by the way, when I arrested him, oh, I didn't do it. And how would he know to say that if I didn't even tell him why he was being arrested? Those are the kind of things that, you know, they're just making it up, because it's not even in their police report, because it's such an important thing. It would be in the police report. It's more like that happens, as opposed to they're just falsifying evidence. So, but with the Kealohas, what I would say is, I don't know if, I can't tell you that they've done this before, but, you know, I represent thieves, I represent con artists, I represent people like the Kealohas who do these kind of things. And I'm telling you, this can't be their first rodeo. In fact, the judge said that when in sentencing, is we don't know what else they've done, but it's highly unlikely this is the first rodeo.
Thank you.
Greg, go ahead, please.
Thank you. First of all, thank you very much for what you've done and what you are continuing to do to get your story out, even with the second version of your book, to update it. We greatly appreciate that. I can't thank you enough. I'll just ask you a brief question. I know there's others that are interested in this topic, but I'll keep this brief. So I'm the board treasurer at my association, and we have systemic and ongoing malfeasance, much of which is being orchestrated by our board president, who is also a public official. He formerly was a deputy attorney general, and he's currently corporation counsel for the city and county of Honolulu. And I'm trying to address certain issues, but my question to you, kind of knowing that you've done this, you know, on the side of law and you know, from the federal side, where can I go? What can I and others, actually, you know, others who are experiencing this, where can we go to address these concerns and issues where we're actually going to get some traction?
Right. You know, I've actually been talked to by a number of people who are talking about their condo association or things like that, where there are these problems going on. And my son lives in a condo where he's having these same issues with certain things happening. You know, it's not my expertise. It's not my area of the law. So I really don't know how, you know, who even in as lawyers do these kind of things. I know Mr. Revere does, but I don't really know who else does. But in terms of traction, you know, it's such a difficult area of the law, and it's so complicated that it's hard to get a prosecutor interested. That I do find is happening. And I know people are frustrated because they don't know where to turn and who to go to. If in your case, which is unique because your person is a public official, that's something the FBI might be interested in, because we're talking about a public official who's using their authority and position, maybe doing something wrong. So that's something I would say, call the FBI. They have a hotline and you can call and you can describe it. And, you know, but I would tell you to be very specific. Don't make broad allegations, have facts, have documents, because they're really not interested in just rumor mongering or bad-mouthing somebody. They really want to, if they're going to get involved, they want hard evidence, hard facts. But because you have somebody who may be a public official, in your case, it might be something they're interested in.
Thank you very much. And yeah, yes, we have substantial evidence, or at least I have substantial documented evidence. Thank you very much for the reply to that. We appreciate it.
Yeah.
Go ahead, Rick.
Okay. So as Lila and I have been setting up these presentations, we've been hearing from folks in very high positions that there's a pretty large federal investigation going on with pretty big things about to happen. Are you privy to any of that?
I'm privy in the sense that I know of it. I know what they're looking at. It's not my investigation. They're in front of the grand jury. I can surmise certain things by reading the pleadings or reading the indictment or reading discovery. But in terms of what they're really doing and what they're after, other than what developed out of our case, like the $250,000 alleged payoff and those kind of things, I know a little bit about that just from what we uncovered or what we know, but I'm not privy to, anything going on in front of the grand jury.
Sure, right. So I just pointed that out because Kokua Council, we've really been all about transparency and really trying to get things to be more transparent and have more of a voice in helping make decisions, things like that. So it seems like we're kind of going in the right direction. Do you think?
I do. That was part of the point of the book, was to get people to action, to voice concerns, to vote, to make things happen and tell our public officials it's not all right. So I don't take credit for all these corruption cases that have come out. I take credit that the Puana case and the Kealoha opened the door and kind of said, do this and it's okay. But what happened after that was really more Mr. Wheat's doing and more now the local U.S. Attorney's Office doing. So I give them a lot of credit for following up. What you need to know is grand jury proceedings. There's a real misconception of this. Grand jury proceedings are secret insofar as the prosecutor is concerned and insofar as the grand jury members are concerned. It is not secret insofar as witnesses who appear in front of the grand jury. So if I were a witness in front of a grand jury, I could go in, offer my testimony or documents, come out, stand in front of the press, and tell them everything that happened. That is not a problem. But a grand jury member or the prosecutor can't. So that's why, like, even with these national things that you're hearing about, we know a lot because witnesses themselves can tell you what's going on. It's just certain people can't, and we won't know until it comes out in the end. Right. So, we kind of can read the tea leaves as what's happening, but that's kind of the process.
Right. Okay. John?
Okay, I haven't bought the book yet. I need to because I want to get to the end. There was something in the news, I can't remember, speculation about Keith Kanashiro's relationship with Katherine, and I don't remember what were they trying to suggest there. The second thing is that every time you saw the couple in the news, they were always holding hands and they love one another and they're devoted to one another. And then all of a sudden, he starts shifting the story that Katherine was the mastermind and he was just kind of like dragged along and didn't fully know what was going on. And so does your book go into those details as well?
Well, of course, I talk about that great picture. It's in the book of them coming to the court in leis when they're indicted. Like, who does that? But I learned a lot about their relationship and their home life and things like that. But number one, unless it's relevant for me to cross-examine, there are a lot of things I learned about that I didn't follow up on, because I'm looking to get my client off and I'm looking for the evidence I can use. We uncovered a lot of things that we turned over to the FBI that we never followed up on, but they did, because it just wasn't something I could use, but it was certainly something they were interested in. I did learn a lot about them as people in their relationship. It wasn't something I intended to use because certain things you just can't use to attack someone's credibility. And a lot of it was rumor mongering. And I'm really not into rumor mongering. And I don't want to destroy people's career, no matter who they are, if I hear something and it's just dirt. So in answer to your question, I learned a lot, but I'm not going to talk about that.
Thank you.
Thank you very much. Eddie girl, you have to unmute yourself.
Thank you. Thank you. So at my condo association, I also have a public figure as our board president. And I've been through all the different agencies to ask for help. I was even on with RICO for over an hour, and that investigator was giving me all the reasons as to what regarding an employee buying personal purchases on our AOA account. And our board president did not inform the board members on what to do. I've also got a receipt from a welding company that we paid out $27,000 plus. And I've checked their state tax ID, which they have on top of the receipt. The format does not go with their company. And I've also reached out to the Hawaii State Tax Department, and they also sent me the report with their original tax ID number. And when you say gather evidence, I mean, like, I think I do have evidence, but I cannot be sure because I'm not a lawyer. What would you recommend? And what?
Right. All I can recommend is, you know, if you folks can afford to hire a condo attorney, then find out who does these, specializes this, and try to at least have a meeting and show them the evidence so that they can tell you whether they think they have a case, you have a case or not. If you can't go that route, and then you should try just going to the police. But I'm telling you, I don't have high hopes when you go to HPD, only because they don't really have a white collar fraud unit that's very active. Neither does the Attorney General's office. That was one of the problems with the state Attorney Generals, and why you're seeing all these federal prosecutions is because they don't really have a robust white collar fraud unit. So it's one of those areas where it's difficult to where you're going to get satisfaction. But what all I can tell you is don't give up. You know, try. I mean, if you can get a lawyer interested who might be able to present your case to a police or who will file a civil lawsuit for you, that's kind of the best way to go.
Thank you. I did reach out to a few real estate lawyers and others, and being that we're self-governed, they say like it's hard for one or a handful of owners to have a case, and that it would take a majority of the homeowners to make any traction or movement. But as you might know from your son living in a condo, that there's only a handful of people that actually care or have time to go to these meetings to fully know what goes on. And I try to bring light to it, being that it's our hard-earned money, but still there's very few homeowners that want to actively participate. Thank you.
So what I would say to you is, though, you have evidence of fraud with that ID number. So you can put everything else aside and just focus on that.
Okay, thank you so much.
Yeah.
Thank you. Lourdes, you're next. Please unmute yourself. Unmute yourself, Lourdes, if you can.
Okay, can you hear me? I just wanted to piggyback Eddie Girl on the $7,000 check. When I became a director, each meeting that I went to, we had to ratify an invoice. So the work was done, we got in our packet the cost of what the job was done, and we all agreed, okay, pay it, because it was to this certain job. We all knew what was happening. And then in recent years, they've done away with ratifying payments on the minutes, which was really curious to me. And I had run across a document somewhere where it says that you don't need to ratify, the board does not need to ratify payments to any vendor or any bill that we have. And I've been trying to search for that document that I had read at one time. And I know I will find it, but I think that maybe we as a group can look into why all of a sudden invoices are not ratified by the board members, because then this would give you a track record of what is being spent on your property, which makes sense, right? Why was it done for 20, 30 years and then all of a sudden it's not there anymore? That's all I have to say. Thank you.
Thanks, Lourdes. Any more questions, concerns, issues?
I'd bring up one. So thank you again for presenting. There was a piece that you shared at the Rotary that I thought was just really humorous. It was about the videotape and the reason you only had like 30 minutes. Could you share that with these guys? I think that was very significant.
Sure. So that video that you saw, as I said, we got a half hour before and a half hour after, and you have that 30-second clip. One of the things we were trying to do, because remember, Katherine says she goes out at 11 o'clock at night and looks through the mailbox and puts mailbox back in. We have the chief claiming he went out in the morning, saw it, and went surfing. And then we have our experts saying it was rigged. So I issued a subpoena to Chief Kealoha himself personally, because I didn't know that I thought these were his cameras. So I issued a subpoena to him personally saying, please give me the entire video. Because when you have a video system, this is a hard drive. This, records hours and days of video, not just an hour. So I issued a subpoena.
Oh, did we lose him?
We lost him. Oh my gosh.
We still have him, but he might have lost connection. Well,
I think I'm back.
You're back. You're back.
All right. So
they're on to you. They're on to you, Alex.
They're on to me, really. So I sent a subpoena to him saying, give me more of the video. And he wrote back saying, oh, I don't have anything. Everything we had, we gave to HPD. I subpoenaed HPD. Now, remember, when I issued these subpoenas, these are federal subpoenas from a judge. I have no authority to issue a subpoena in my name. I have to go to a judge, convince the judge to issue the subpoena to, and all the documents are returnable to federal court. So HPD respond, affidavit, under oath, you got everything we got. Well, at the trial, when Officer Silva, who is the custodian of records, I showed you his documents, was on the stand and introduced the video, I asked him, is there more? And he looked at me and said, of course there is. And I go, where is it? And he goes, it's in my office in CIU. And I go, well, how much more is there? Hours? He goes, yeah. I go, days? He goes, yeah. I said, weeks? He goes, yeah. So even though I had subpoenaed both Louis himself and HPD, and they had denied there was more videotape, it's sitting in his office. Now, after the case was over, and this is the fun part, the FBI went in with a search warrant and raided CIU. I mean, think about that. FBI is raiding your police department. They go into CIU to get and find that hard drive. Well, this is what they found. When we issued the subpoenas, CIU took the hard drive, put it in the camera, put the camera on the floor of the CIU office, pointed it at the ceiling of CIU, and for 6 days recorded over the videotape. Now, why do you do that? If you delete a videotape, you can recover it. If you video over a tape, you can't. And they know that, they're police. So what happened was, though, the reason the FBI was able to know that this happened is because they actually found the hard drive. And what had happened was, for 6 or 7 days, that hard drive is shooting straight up at the ceiling. But CIU technicians, every once in a while, look into the camera lens to make sure it's working. So their faces are there. But the other thing they did was they put it on automatic, and it stopped 30 seconds too early. So if at the end of this whole 7 days, there's still 30 seconds of the original videotape left. So the FBI was able to recover it and found out that they had intentionally taped over the entire thing. Think about that. Your CIU is doing this. That's pretty amazing. I mean, this is pretty blatant.
Well, it's alarming.
Yeah. But it was one of the more, I mean, one of the more funny aspects of this case, as it turns out, was not only that, and of course, I didn't know this. You know, this isn't something we uncovered. It was something that Officer Silva said, oh, yes, there's a hard drive, but I did not know that they had done this. But the other thing, of course, that was amusing, you know, in this case is this mysterious Allison Lee Wong figure who Katherine just makes up as a person. And if you don't know this, Allison Lee Wong, who she made up as a notary, she actually got a notary stamp in her name, and she would use it to notarize her own documents. But better than that, when people complained to ODC about her, who was one of the people saying that she was a great lawyer and didn't do anything wrong? Allison Lee Wong. And when she applied to become head of an administrative office under Lingle, who wrote a letter to the Senate Confirmation Committee on her behalf? Allison Lee Wong. So, I mean, this is just unfathomable. It's just amazing what Katherine was doing.
So, Mr. Silvert, what you began, you opened the door, but are we just scratching the surface?
Unfortunately, I think we are. I think the indictments that you're seeing so far, you know, I don't know if they're valid or not. And, you know, I want to make it clear, I'm a defense attorney. You know, just because someone's charged with an indictment doesn't mean they're guilty. So I'm not at all going to say that any of these people are guilty because I don't know. But the fact, I mean, there was a lot of stuff going on, and there is a lot of stuff going on. It's a question of, can we get people coming forward to tell us that that's what's going on? And then we need prosecutors who are interested in prosecuting it. You know, I'm not a prosecutor, and I was always a defense attorney. I'm not friends with prosecutors. That I was always against them. And but I will say this, you know, it's very difficult if you're a prosecutor to do these kinds of cases, because if you're wrong, it's not even a matter if you're wrong. If you prosecute a high public official, you're not going to become a judge, which is what a lot of prosecutors want to do. You're not going to get hired by a big law firm because you made trouble. And we live in a small, insulated community of lawyers. And prosecutors, a lot of them, want to become judges. They want to become high-paid members of law firms. And if you do this, you're in trouble, you know, politically and socially. So I'm hopeful that what's happening, it will open the door, because there's a lot out there. I mean, you know, people have come forward to me, whistleblowers, and told me things. I don't know if any of it's true, but as we get more and more people willing to talk, I think you're going to find that there's a lot of things going on.
So in your book, towards the end, of course, and I brought this up the introduction today, you mentioned he who shall not be named. Do you still have that feeling?
Well, he who should not be named has been arrested. So I can say who it is, because, you know, in the book, for those who want to haven't read the book and you don't want to know, close your ears, because it's kind of fun, because the way we did this was, this was something my wife and I did, and we took it very seriously, because a lot of people asked if we'd been threatened or what happened, you know, things during this whole time period. And I wrote a chapter called Voldemort, which is a takeoff on Harry Potter, of course, because there was a figure, a very dangerous figure, who we had heard was associated with Katherine, who we were a little worried about, because if Katherine went off the rails, we felt something serious could happen if the connection between her and this other person was true. I don't know if it's true. To this day, I don't know if it's true. So I don't want to say they are connected. We just heard a lot of rumors. So as a result of that, we did close our blinds so none of us faced the street. I did make sure the cars were all checked out and safety inspections and registered. You know, we were a little careful about making sure we didn't speed. And as a former cab driver, that's a little hard for me. And so we did take precautions, and we were never directly threatened per se, but we felt it was a possibility. And that's what that chapter is about. Now, the person, I'm not going to name his name because that's part of the fun. But if you read it, you'll know who it is. If you're from Hawaii, you'll figure it out. But it was really, we would not say the person's name. It was not a joke. We just felt like it was better not to.
Thank you. All right, well, it's almost 1 o'clock. Mr. Silvert, would you like to provide us a closing statement?
Yeah, I guess my closing statement would be, I really need people to get involved. I really want people to get involved. The Foley Commission was a great step forward, but most of the more important and serious aspects of the commission's recommendations did not get passed. I call it window dressing got passed. I mean, it was still a step in the right direction. It was still an effort, but not a lot got accomplished. And the only way we're really going to force government and our government to change is if people get involved and demand it to happen. That's either by voting or by letting your representative know or attending meetings, whatever it takes. But that's at the state level. The city and county level, which are all the institutions in my case that failed to do anything, have done nothing. They literally have done nothing. And in the police commission, while the mayor, appoints and, the city council approves, but the mayor really appoints, has appointed 1 or 2 people who are knowledgeable and willing to shake the boat. If you only have 2 members out of 7, and you know this from the condo association, you're not going to get anything done. You're just going to be the opposition. So until the way we select commissioners and who's empowered to select commissioners changes, none of this is going to change. And we've seen that the city and county is absolutely refusing on all levels to do anything. So these are the things that I urge you, if you have connections, if you know people, if you want to go to meetings, to vocalize, because this is only the beginning. And to me, the mantra that people have been saying in the police department and the powers that be, that these are a few bad apples and we got rid of them, is completely a false narrative. And as long as they're able to stonewall and stop real change, this is going to happen again. It's just going to be 10 years down the road, and it might be your relative. So I really encourage people not to give up. You can't give up. We can only make change if we get involved. And you are the type of people that will do that. So that's my last parting words, is get involved.
Thank you, Mr. Silver. When you look on the screen, many of us are whistleblowers. And like what you felt, many of us feel some, that there could be some danger lurking for us because of our positions, but we bravely go forward. So thank you very much. To everyone who joined us, we thank Mr. Silver for his interesting presentation today, and especially for your diligent work, Mr. Silver, regarding the investigation and conviction of the Kealohas. Last month, Judge Daniel Foley, who led the Commission on Standards of Conduct, joined us. And next month, and Mr. Silver, you're invited to join us again, Honolulu prosecuting attorney Steve Alm will join Kokua Council. And he would be the 3rd in a series regarding corruption. We hope that our meetings at Kokua Council helped encourage reforms to rebuild public trust. Mahalo to all of you for taking time out of your busy schedules to join us. Kokua Council invites you to join us next month during our hybrid general meeting on Monday, August 28th. Again, we plan to hold our meeting at the Pali Honganji, but it will be a hybrid. You will have the opportunity to Zoom in. Mahalo to everyone for joining us, especially Mrs. Silver. Thank you for a very entertaining book, The Mailbox Conspiracy. I look forward to your sequel. Thank you. Aloha, everyone. I'm going to adjourn this meeting. Mahalo.
Oh.